The Supreme Court, as I earlier told you, Supreme Court judges are expected to make rulings on several election petitions, including one at the Embakasi East parliamentary seat. The appeal was filed by poll loser Francis Muriithi, whose petition was dismissed in the Court of Appeal, or the Court of Appeal rather. A decision on the Eldama Ravine parliamentary seat and the Lamu senatorial seat will also be delivered. In the Eldama Ravine case, former Minister Musa Sirma is challenging the election of Member of Parliament Moses Lesonet. But for now, we understand that Justice Moking Wanjala of the Supreme Court is making a determination or delivering their judgment on a case involving Marakwet East parliamentary seat. Let's listen into what he has to say.
Irregularities on the result of the election. None of these questions, in our view, were resolved through the interpretation or application of the Constitution. On the contrary, the Court of Appeal decided all these issues on the basis of settled applicable legal principles as established by this court in earlier decisions where similar questions had arisen. There was no question of constitutional novelty to which the appellate court applied its mind so as to activate the appellate jurisdiction of this court under Article 1634A of the Constitution. In his submissions to the effect that the jurisdiction of this court had been properly invoked, counsel for the petitioner placed a lot of reliance on this court's pronouncement in what we call Munyawan, to the effect that the Elections Act and the regulations thereunder are normative derivatives of the principles embodied in Articles 81 and 86 of the Constitution, and in interpreting them, the court of law cannot disengage from the Constitution. We wish to reiterate that the foregoing statement still remains jurisprudentially sound and conceptually and logically correct, but it is not a carte blanche for invoking this court's jurisdiction under Article 1634A of the Constitution. The context under which it was rendered was extensively explained by this court in Evans Odhiambo Kidero versus Ferdinand Waititu. Towards this end, an appellant must still convincingly bring his appeal within the coordinates of Article 1634A as established by this court in past decisions. This takes us to the second issue, and that is whether the Court of Appeal acted in excess of its jurisdiction under Sections 85A of the Elections Act. Towards this end, we have carefully considered the judgment of the Court of Appeal. We are satisfied that in assuming jurisdiction, the learned judges of appeal fully appreciated the frontiers of Section 85A of the Elections Act as established by this court in Gatirao Peter Munya versus Dixon Mwenda Kithinji. This being the case, we find no basis upon which to conclude that the appellate court acted in excess of its jurisdiction. Applying these principles to the case before us, we have no hesitation in holding that the petition of appeal cannot be sustained as it does not involve any question of the interpretation and application of the Constitution. It follows that the preliminary objection is one for allowing. This then leads us to the following orders. 1. The preliminary objection is hereby allowed. The petition of appeal is hereby struck out. The judgment of the Court of Appeal dated 12th July 2018 is hereby upheld. For the avoidance of doubt, the declaration of the result of the election by the IEBC in respect of a Member of Parliament from Marakwet East constituency is hereby affirmed. The petitioner herein shall bear his own costs and the costs of the first respondent. The second respondent shall bear its own costs and those of the third respondent. It is so ordered.